we will begin our session now. Good day from Malaysia, teams and arbitrators. Thank you for joining with us today and welcome to the semi-final rounds of the International Commercial Arbitration Moot Championship, ICAMC 2021. My name is Wong Chiyong and I'll be acting as a bailiff for today's session. The match will begin shortly. We will now proceed to the dry run session. Hi, lead counsel from claimant. Can you see me and hear me?
Hi, good morning. I can see you.
All right. Lead counsel from respondent, can you see me and hear me?
Yes, I can see you and hear you.
Thank you. Second counsel from claimant, can you see me and hear me?
Yes, I can see you and hear you.
Thank you. Second counsel from respondent, can you see me and hear me?
Yes, I can see you and hear you.
Thank you. Mr. Daniel Chua, just to confirm, you can see me and hear me?
Yes, I can.
All right. Ms. Lavinia and Ms. Tawai Fong, you can see me and hear me as well?
Yes, I can.
Yes, I can.
All right. Thank you. That's the end of our dry run session. Teams and arbitrators, for your information, this meeting is recorded and the video will be uploaded by our organizing committee after the competition. First and foremost, I would like to congratulate Team 1002 and Team 1004 for making it to the semi-final rounds. We will now proceed. With the discussed details between the counsels of the claimant and the respondent regarding the
Yeah, I think we're moving on to housekeeping matters. Yes.
Yes. The procedural timetable for today's hearing.
Right. Can I ask whether counsel for both parties have had an agreement as to the order of the hearing and order of presentation?
Good morning. The Council for Claimant proposes that we use the RCCR method, that is respondent procedure and claimant procedure, followed by claimant merits and the respondent merits. And each of the participants from the claimant side will take 17 minutes each, followed by the rest of time to rebuttals. That is okay with the respondents?
Right, thank you. So I think before we begin proper, I think it's only customary that we do share a little bit of introduction between ourselves. So I will take the start and followed by my co-arbitrators. My name is Daniel Chua. I'm an associate at Herbert Smith Freehills. I practice international arbitration and international dispute resolution. I'm very happy to be here today and I wish the parties all the best.
Good morning, everyone. My name is Lavinia Kumarindran. I practice in the chamber set called Lavinia Barland and Chambers. I've been in practice for about 15 years now. With a little bit of touch of the commercial arbitration, my primary area of practice is in litigation, but commercial disputes in litigation. I'm happy to be with you and thank you for the organizing committee for inviting me this morning. All the best to both teams, regardless, you're here today, so give it all you got.
Hi, good morning, everyone. My name is Tay Wai Fong, and I'm an associate in the arbitration team of BD Samudin. I've been there about now for 1 to 2 years. I guess my arbitration is mostly in the energy area, although a few construction matters. And I will echo what Daniel and Lavinia said. Congratulations on reaching the semi-final, and all the best for today.
Thank you, arbitrators. May I kindly request the council to stipulate the discussed detail just now in the chat box according to the format which has been sent by my colleague just now?
I believe we need a response from the Respondents' Council.
Yes.
Certainly, Mr. Arbitrator, we're just filling the form. Thank you so much.
Thank you, participants, teams, and arbitrators. Before the session begins, I would like to provide a brief of the rules. First, each team is allocated maximum 40 minutes to submit their issue. Second, participants, you are kindly reminded to mute your microphone when you are not submitting and kindly keep your camera on at all material times. Mr. Daniel, we have already privately messaged you the score sheet documents using the chat box. Could you please check on the document and see if it can direct you to the Word file? While here is a reminder that the score sheet has been updated, containing the councils and the team's name that has been advanced to the SEMI. There is some slightly changes to the score sheet and the team names.
No, I've not received anything. We
My
can take it.
apology, Mr. Daniel. Our secretariat will send you right now.
Yep. Okay. If there are no further housekeeping matters to discuss, I think we are ready to proceed.
All right. Mr. Daniel, I'm so sorry. Could you please check the, may I request you to check the chat box again, as our technical team has successfully sent the document to you?
Yes, I've received it. Thank you.
Yeah. Well, for Ms. Lavinia and Mr. Ted, we have also privately messaged you the score sheet link using the chat box. Could you please click on the link and see if it can direct you to the Google Drive?
Yes, it's working.
Yes, I've got it. Yes.
All right. Thank you, Mr. and Madam Arbitrators. You may fill in the score sheet throughout the session, and should you have any inquiries, feel free to seek clarification from us.
Thank you.
That's the end of our briefing of rules, and our session will begin now. Participants and arbitrators, thank you for joining with us today, and welcome to the semi-final round of the ICAMC 2021. We are honored to have Mr. Daniel Chua as the presiding arbitrator, followed by Ms. Lavinia Kumariandran and Mr. Tewai Fong. The match between Team 1002 and Team 1004 is now in session. The arbitral tribunal may now progress the arbitral proceedings. Mr. and Madam arbitrators, you may have the floor.
Thank you, Bailiff. We have discussed earlier the order of proceedings, and I think we have noted the time allocations agreed by the parties. So we are ready to proceed proper. So counsel, anytime you are ready.
Thank you, Mr. Arbitrator. Am I clearly audible and visible?
Yes, we will let you know if we are unable to hear you or see you.
Thank you. Greetings, members of the tribunal. My name is Nandini Goyal, and along with my co-counsel, Anisha Sharma, I will be representing the Zoka Green Energy Limited in the present matter. The claimant had filed a request for arbitration with this tribunal pursuant to Rule 2 of AIAC Arbitration Rules 2018 on the 20th of March 2021. My client challenges the jurisdiction of the tribunal to hear the dispute in the present matter. Over the next 17 minutes, I shall demonstrate the same using the following three broad arguments. Firstly, the arbitration agreement shall be governed by the law of the main contract, that is, the law of WAS. Secondly, the pre-arbitration requirements were required to be met by the claimant before filing for arbitration. And thirdly, the tribunal in the present matter would risk issuing an unenforceable award. Now, commencing my first argument, that is, in relation to the arbitration agreement being governed by the law of the main contract. The claimant has raised the issue that the arbitration agreement shall be governed by the law of the seat of arbitration, that is, Elirad model law. However, I argue that the arbitration agreement shall be governed by the law of main contract, that is, law of force. And I will base this argument mainly on three sub-arguments. Firstly, that the law governing the arbitration agreement should not be taken as separate from the main contract. Secondly, the choice of governing law for main contract should be taken as the express choice of law for arbitration agreement. And thirdly, that the implied choice of law of parties for the arbitration agreement should be the governing law of main contract, that is, law of force. Now, claimant has argued that the doctrine of separability shall be applicable in the present matter, and therefore the law governing the main contract should be taken as separate from that of the arbitration agreement. I would contend this argument. It is recognized that the concept of separability cannot be used to prevent a court from construing the arbitration provision together with the remainder of the main agreement. This was observed in the Sula America case. In fact, despite being autonomous, the arbitration agreement has an obvious link with the host contract, since it is intended to govern the disputes arising from that contract. Therefore, in the present matter, the arbitration agreement should not be taken as separate from the main contract. Now, coming to the choice of governing law for the main contract being taken as the express choice of law for the arbitration agreement, I would be using the three-step test laid down in Sula America. The first condition in that test corresponds to the express choice of law. Now, although the parties did not agree on an express choice of law for the arbitration agreement, however, it is recognized that a choice of governing law for the main contract can amount to an express choice of law for the arbitration agreement, and in such circumstances will not be displaced by the party's choice of an arbitral seat in a different jurisdiction. This was observed in the case of Kababji SL versus Scout Food Group. Earlier, the arbitration agreement proposed by the claimant had a provision which expressly provided for the law of default to be the law governing the arbitration agreement. However, when the respondent had requested to provide for the law of was to be the law governing the arbitration agreement, the clause was updated and the provision of law of default being the choice of law for arbitration was removed, and law of was introduced as the governing law for the main contract. This can be observed in para 9 of the Moot problem. This clearly shows that the law of was should be construed as the express choice of law for the arbitration agreement. Now, coming to the implied choice of law of parties for the arbitration agreement, it has been recognized that the implied choice of law for the arbitration agreement is likely to be the same as the expressly chosen law of the substantive contract. This was observed in the case of BCY versus BCZ. Where the arbitration agreement is a clause forming a part of the main contract, it is reasonable to assume that the contracting parties intend their entire relationship to be governed by the same system of law. If the intention is otherwise, it is unreasonable to expect the parties to specifically provide for a different system of law to govern the arbitration agreement. Also, in the present matter, I would like to draw to the attention of this honorable tribunal that there was a governing law clause providing for law of was for the whole contract, as observed in para 9 of the Moot problem. No separate law to govern the arbitration agreement has been provided as such. Also, there is an entire agreement clause in the agreement, which can be observed in para 11 of the Moot problem in the article 1 of the main contract. Therefore, the governing law clause provided for the main contract, that is law of was, should be applicable, and no negotiations which do not form part of the contractual terms should be used to determine the implied choice of law. If I have the permission of the honorable tribunal, I would like to move to the second prong of my submission, that is my second argument, which relates to the pre-arbitration requirements. Thank you.
Also, before you proceed, I have a couple of questions. You did make reference to Sulamerica, which I think we all understand is the Court of Appeal, or it could even be the Supreme Court decision from the UK courts. Is there any particular reason why we should be referring to Sulamerica and not some other common law case law?
Certainly, Mr. Arbitrator. First of all, I would like to point out that all the cases have a persuasive value on this honorable tribunal. However, Sulamerica case holds a special value because it is one of the most recognized cases, and the test laid out in Sulamerica case has been widely used in the subsequent cases to determine the law governing the arbitration agreement. Therefore, in the present matter, I would draw to the attention of the honorable tribunal that Sulamerica test should be used because this case has been recognized and used several times in the following cases. So that would be my submission.
I have a couple of follow-up questions as well, if my tribunal members will indulge me as well. Does your argument or submission change, or rather, how would the fact that the Supreme Court recently in Enka against Chubb provided for a different reasoning in respect of the law governing the arbitration agreement, would the case of Enka and Chubb impact your submissions?
Certainly not, Mr. Arbitrator. And my reasons for saying so are because in the case of Enka versus Chubb, I remember reading that this would apply only to a minority of cases, and that would be depending on the facts of the case. In majority of the cases, we need to apply that Enka Insat. Actually, Enka Insat would be applying to the present matter because you have used Enka Insat, and that would be actually helpful to our case. And in the present matter also, we have this law of the main contract governing being used. So this particular case of Enka Insat would actually be in our favor. So I think if we apply Enka Insat versus Chubb in the present matter also, that would rule in our favor. So the judgment won't change even if you apply it.
Why would it be in your favor?
Because in the reasoning provided in Enka versus Chubb, it was held that the law governing the main contract would be the one applying to the law of the arbitration agreement. So that would be in our favor. That is because what we are arguing in the present matter. So that is a case that would actually be in our favor, even if that is applied.
My second follow-up question is this. There is also a recent decision by the Singapore Court of Appeal in BANA against DNB, which again deals with the law governing the arbitration agreement. How, if at all, would this case impact your submissions?
Mr. Arbitrator, I would like to request you to kindly reiterate the case name because I didn't get the name of the case correctly, if you could.
BNA, letters beta, Nairobi, America, versus BNB, beta, Nairobi, beta. It is a decision by the Singapore Court of Appeal which deals with how one would determine the law governing the arbitration agreement.
Mr. Arbitrator, I have not used this case in my pleadings, so I personally would not think that this case would impact it because I'm not using it for my reasoning in the present matter.
Right. Okay. Okay. I've got no further questions on this point then. Unless my fellow arbitrators have any further questions, you can move on to the next point.
Certainly, Mr. Arbitrator. Now, moving on to the second prong of my submission, that is to the second argument relating to pre-arbitration requirements. Now, I argue that the pre-arbitration requirements were required to be met by the claimant before filing for arbitration because of these three sub-arguments. Firstly, the pre-arbitration clauses are mandatory requirements to arbitration under WAS law. Secondly, the request for arbitration is premature as the claimant did not fulfill the 30-day pre-arbitration requirement. And thirdly, due to the entire agreement clause, the pre-arbitration requirement of 30 days provided in Article 13 of the contract cannot be derogated from. Now, first of all, as I have established in the course of my pleadings, that WAS model law, that is the law of main contract, shall be applicable. And I would like to draw to the attention of the Honorable Tribunal para 23 of the Moot problem, which clearly states that under the WAS model law, the pre-arbitration clauses are considered to be a mandatory requirement. Also, it has been observed that where the party's intent is clear, courts and arbitral tribunals hold such pre-arbitration requirements to be mandatory with potentially significant results. Therefore, in the present matter, the pre-arbitration requirements must be deemed mandatory. Now, coming to the second subpart, that is relating to the arbitration request being premature on the grounds of non-fulfillment of the 30-day pre-arbitration requirement, I would like to draw to the attention of this court that in para 9 of the Moot problem, a 30-day pre-arbitration requirement was provided under Article 13, subclause 2, which were not met by the claimant. The pre-arbitration proceedings were initiated on the 10th of March 2021, and the claimant filed the request for arbitration on 20th of March 2021. Now, this amounted to only a 10-day gap instead of the specified 30-day period, which was in clear violation of the specified period. Various such premature requests have been dismissed by international tribunals in the past. In one case, the arbitral tribunal held that the request for arbitration was premature and dismissed the arbitration because of the claimant's failure to complete the pre-arbitral dispute resolution steps. Similarly, another tribunal concluded that the pre-arbitration procedures were strictly binding upon the parties and govern their conduct before resorting to arbitration. Therefore, I plead that the request for arbitration filed by claimant in the present case was premature and as such should be dismissed. I would also like to point out that there was an entire agreement clause in the contract. Now, I would like to draw to the attention of this court, Article 1 in the main contract, which could be referred to in para 11 of the Moot problem, which was an entire agreement clause. And as I've already elucidated in my previous arguments, that a 30-day arbitration requirement was provided. Therefore, the claimant was not allowed to derogate from the terms and was supposed to fulfill the pre-arbitration requirements mandatorily, because unless he does that, that would be in violation of the entire agreement clause, because any negotiations or terms which do not form part of the contract cannot be said to be hold true in the presence of an entire agreement clause. Therefore, I plead that due to the following reasons, the pre-arbitration requirements of 30 days should be held compulsorily mandatory, and the claimant should be held in violation of not fulfilling the 30-day pre-arbitration proceedings, and as such, this case should be dismissed. Now, with the permission of the Honorable Tribunal, I would like to move on to the third prong of my submission, that is my third argument relating to enforceability.
Counsel, I have a question. Assuming that we are with you, that the 30 days negotiation requirement is part of the dispute resolution clause in question, does the fact of its non-compliance go into the affect the jurisdiction of this tribunal, or does it merely affect the admissibility of the claim at hand?
That would be going into the admissibility of the claim as well, and that would then substantially affect the jurisdiction, because since the pre-arbitration requirements have not been met, then I would be showing how it could lead to an unenforceable award under the New York Convention, because being outside the scope of the parties' agreement. So that would be something that I say, first of all, affects the admissibility of the case, and secondly, would impact the jurisdiction as well.
What is the difference between an impact on the admissibility of a claim and the jurisdiction of the tribunal?
Mr. Arbitrator, though on the outset, they both look like very similar terms because, jurisdiction, when we're questioning the jurisdiction of a tribunal, we're actually saying whether it could hear the case or not. And admissibility also somewhere or the other refers to the part that whether this case could be taken into by the tribunal. However, there would be a certain slight difference in both the terms because a case might be admissible, but the tribunal might not have the jurisdiction to hear the dispute. However, when it comes to admissibility, it would be like it cannot be admitted into this court. So it's a little slight difference, but they are quite similar in sense. So that would be my submission.
I'll reserve my comments on those submissions, but let me then ask you this. Assuming then, as you mentioned, that this goes into a question of admissibility in the first instance and followed by jurisdiction. I'm not sure how that connects, but assuming that it just goes into admissibility in the first instance, assuming that the tribunal decides to stay this arbitration for 30 days for the parties to go and negotiate, and and after 30 days, the tribunal will reconvene in order to ask the parties whether a settlement agreement has been reached, and if not, if no settlement agreement has been reached, whether the tribunal can continue to hear this matter. Would that remedy this non-compliance?
Mr. Arbitrator, could I kindly request you to rephrase the question because I couldn't get the gist of what you asked.
Put it in a short manner. If this tribunal decides to stay these proceedings for 30 days for the parties to negotiate as required under the dispute resolution clause, does that cure the non-compliance? Assuming, of course, that the curing of the non-compliance means that we now can continue to hear the dispute.
Mr. Arbitrator, I would like to bring to the notice of this tribunal that in case the pre-arbitration clauses are held to be, the 30-day pre-arbitration requirements are met, then there would still be other questions pertaining to certainly like the law governing the arbitration agreement. Those questions would still be standing. That would challenge the jurisdiction of the tribunal.
Yes, those questions, of course, will still be standing, but I'm asking you, does the question of the inadmissibility of this claim becomes cured as a result of the proposed action by the tribunal? That's my question.
Mr. Arbitrator, it would be my sincere and humble request that this case be disposed of, and if the claimant wants the proceedings to be initiated, then in that case, it needs to restart the 30-day pre-arbitration requirements, and after that, a new case should be initiated. So this case I would still contend that this case should not be admissible, and I would actually contend the jurisdiction of this case. So those are the two things, Mr. Arbitrator.
All right. I think if there are no further questions from my fellow arbitrators, you can proceed with the next point.
If I may just raise one issue.
Certainly, Madam Arbitrator.
Following through from the arbitrator's question earlier, if at all we do stay the arbitration to allow that 30-day period for negotiations to happen, I understand that your submission is that it be dismissed from the onset. But would you not agree that you are, if at all we are with you on that argument, you are or you will be entitled to a payment of damages instead, but not to have this arbitration not continue? Would you agree with that proposition?
I would differ with that proposition, Madam Arbitrator, because my contention in the present matter is that this case be dismissed on the grounds that the tribunal doesn't have jurisdiction to hear the present dispute. So,
yeah, putting aside those live arguments
certainly
on the issue of jurisdiction, but purely on the fact that the 30-day you say has not been met for whatever your arguments are. If we were to stay this, allowing parties to go ahead, fulfill that 30 days and come back to us on that, would you not agree that if we decide as such, or if the tribunal decides as such, your claim would be to the extent of contractual, say, damages for that absence of the 30 days, if we're with you on that argument?
Madam Arbitrator, I don't think that we have, because we're only referring to the procedural issue here. We have some merit issue involved in the case as well. So we would be considering those issues as well before we actually raise this contention. But certainly, I would like to respond to your point. I think I would first of all contend that this case should be dismissed on the onset, here and now. Secondly, it would be maybe we could claim damages if the tribunal deems fit, but that is not our main contention over here. Our main contention right now over here is to get the case dismissed on the basis of the tribunal not having jurisdiction to hear the present dispute. That would be our main claim.
Very well, I have no further questions.
Thank you, Madam.
I would like to ask one question, and I think I will attempt to sum up what I think my co-arbitrators have asked. Apart from 30 days, you seem to say, Counsel, that there are other reasons why the respondent would still be challenging the jurisdiction. So what are those other reasons, apart from the alleged non-compliance with the 30-day requirement?
Certainly, Mr. Arbitrator. I would like to point out that I've argued that the law governing the arbitration in the present matter should be held to be Elirad model law, or should be held to be WAS model law, that is the law of the main contract, and not Elirad model law as pleaded by the claimant. That would be one issue. Then there are other issues as well, such as apart from the 30-day pre-arbitration requirements not being met, the claimant has filed this case with the wrong law, that is the law of Elirad. So that would be my main contention. And there are reasons apart from that as well, but my main contention would be the strongest argument would be that the law governing should not be the Elirad model law, but WAS model law.
All right, thank you. I think we can proceed.
And also, I would also like to point out that in the present matter, it would lead to an unenforceable award, as I would be pointing out. So that was also another issue we can focus on. Now, with the permission of the Honorable Tribunal, I move on to the third prong of my submission. That is my third argument relating to the unenforceability of the award. Since, as observed in para 27 of the Moot problem, the New York Convention is a law governing the enforcement in the present matter. Therefore, I argue that by hearing the dispute, the tribunal would risk issuing an unenforceable award because it would not be, the arbitral procedure would not be in accordance with the agreement of the parties. Article 5(1)(d) of the New York Convention provides for the refusal of recognition or enforcement of an arbitral award if it is not in accordance with the agreement of parties. Article 36(1)(a)(4) of model law is also representative and models the same concept as Article 5(1)(d) of the New York Convention. Now, since in the present matter, as I've already pointed out, that the 30-day pre-arbitration requirements have not been met, which were required to be met because of the anti-agreement clause and the reasons stated above and the terms of the contract. And also, as I have shown that the tribunal doesn't have the jurisdiction in the present matter. Therefore, I plead that in the present matter, the tribunal would risk issuing an unenforceable award under Article 5(1)(d) of the New York Convention. Therefore, I would humbly request the Honorable Tribunal to dismiss the present suit and not hear it, as it would be going against the jurisdiction on the following grounds as I've elucidated above. And with that, I would like to rest my case. Thank you.
All right. If there are no further questions, I think we can move on to the response. I will have to note, however, that counsel, you have exceeded your time by, I think, about 6 minutes. So that may have to be taken against the time for your co-counsel. So Claimant's Counsel, anytime you're ready.
A very good morning, members of the tribunal. My co-counsel Abhishekta Sengupta and I, Seva Shukla, together represent the claimant, Futuri Unique Solar, in these proceedings. I shall be dealing with the procedural issue, that is issue A, of whether the arbitral tribunal has the jurisdiction to resolve a dispute between the parties, and specifically which law governs the arbitration agreement. Further on, my co-counsel shall argue the substantive issues, that is issue B and C. Members of the tribunal, we are here today because the respondent breached their obligations of providing 10,000 photovoltaic panels, and the oral variation made by the respondent was invalid under the Ultra Solar Project Agreement entered between the parties. Before we can get into the substantive issues, however, the procedural question regarding the arbitral tribunal's jurisdiction must be answered. I will do so through the course of my submission. I shall address the procedural issues in two limbs. First, that the law of the seat of arbitration, that is, LIRAD law, governs the arbitration agreement. And second, that the pre-arbitration clause does not preclude the jurisdiction of this arbitral tribunal. Now, on the issue of proper law, we submit that the law of the seat, that is, LIRAD law, governs the arbitration agreement. In the present case, the parties did not expressly choose a law to govern the arbitration agreement. They did, however, explicitly choose LIRAD as the seat of arbitration, as mentioned under Article 13(2) of the Ultra Solar Project Agreement, given in paragraph 9 of the Moot problem. I shall follow the three-stage test that was laid down in SulAmérica and ENSA case to prove that in the absence of an express choice of governing law, LIRAD law will govern the arbitration agreement, since first, the law governing the substantive contract does not extend to the arbitration agreement due to the separability doctrine. Second, that the parties implicitly chose LIRAD law to govern the arbitration agreement. And third, that the LIRAD law has the closest and the most real connection to the arbitration agreement. Now, on the first point, members of the tribunal, the law governing the substantive contract does not extend to the arbitration agreement due to the separability doctrine. Now, as per the separability doctrine, the arbitration agreement has a separate existence from the underlying contract. The law governing the arbitration agreement may be different from the law applicable to the underlying contract, as the function of an arbitration agreement is distinct from the function of the substantive contract. Several decisions follow the same core reasoning, holding that the choice of law in the main contract does not automatically apply to the arbitration agreement as well. If I may invite the tribunal to refer to paragraph 9 of the Moot problem, the Ultra Solar Project Agreement contains a clause that provides for the contract to be governed by the law of vows. But the seat of arbitration was chosen by the respondent to be LIRAD, specifically selected for the neutrality it would afford to the parties. Given the context within which the terms of this contract were drafted, the mere absence of an explicit choice of law governing the arbitration agreement cannot be construed to mean that the substantive law will extend in its application over the arbitration agreement. Therefore, the contention that the law governing the substantive contract will automatically also govern the arbitration agreement is unsustainable. Further, members of the tribunal, the parties implicitly chose LIRAD law to govern the arbitration agreement. Now, in the absence of an express reference to a governing law for the arbitration agreement, the parties' implied choice must be examined. the intention of the parties is the key to determining the implied choice of law governing the arbitration agreement. And to establish this intention, the sound ideas of commercial interest, along with the surrounding circumstances of the dispute, must be examined. Now, in the present case, the parties explicitly chose Elirad as the seat of arbitration because of the neutrality it would afford, as given under paragraph 9 of the Moot problem. Secondly, a reference to the drafting history of Ultra Project Agreement provides an insight into the surrounding circumstances leading up to the dispute. The claimant initially proposed a dispute resolution clause that provides for the seat of arbitration to be Dafal and for the arbitration agreement to be governed by the law of Dafal, as mentioned in paragraph 8 of the Moot problem. This expressly reflects the intention of the claimant to have the seat of arbitration and the law governing the arbitration clause to be the same. The respondent agreed to the overall proposal and only asked for the seat of arbitration to be changed to a neutral location, along with the insertion of a pre-arbitration clause. The claimant complied, but brought up the need to insert a clause specifying the law governing the arbitration agreement for the purpose of clarity, failing which it shall be the law of the seat that will govern the arbitration agreement mentioned in paragraph 10 of the Moot problem. Even though the respondent expressed disinclination to fall back on the seat of arbitration, the respondent did not express any intention to have the governing law of the substantive contract extend to the arbitration agreement. Claimant repeatedly made clear their intention to have the law of the arbitration agreement be the same as the law of the seat, and there was nothing that suggests that the respondent intended to have the substantive law apply to the arbitration agreement. Thus, by choosing Elirad's seat of arbitration, the parties implicitly chose Elirad law as the governing law of the arbitration agreement. Even if it is assumed that both the parties express and implied choice are absent, the law of the seat still applies because it has the closest and the most real connection to the arbitration clause. The members of the tribunal in the recent case of Enka and Sharp, it was held that the arbitration agreement has its closest connection with the law of the place where the arbitration is to be held, which will exercise the supporting and supervisory jurisdiction necessary to ensure that the procedure is effective. In the present case, the seat of arbitration is an Elirad. From the legal standpoint, it can be inferred that the curial law in this case will be the law of Elirad. This points to Elirad having a more real connection to the arbitration agreement. Meanwhile, the law of vows has no connection to the procedural elements of the arbitration process, since it is merely the law governing the underlying contract. Therefore, it is the law of Elirad that has the closest and the most real connection to the arbitration agreement. Now, if I may move on to my second submission.
Counsel, I do have a question for you.
Yes,
Is it allowed under either Dafal law, Elirad law, or Vows law for the tribunal to be considering the negotiation history of the parties in order to integrate this gap in the arbitration agreement?
Okay, Mr. Arbitrator. So the drafting history is necessary and must be looked into by this tribunal in order to establish the intention of the parties. And the intention of the parties must be taken into consideration because the sound ideas of commercial interest along with the surrounding circumstances of the dispute must be examined. And the similar was held in the case of NTPC versus Singer. Hence, it is an important aspect to consider the intention of the parties while looking into the historical aspect, and this tribunal must do so while determining the same. If you are satisfied with the answer.
Yeah, that's fine. Can I just check with you? So your submission is that the law governing the arbitration agreement should, in these circumstances, follow the law of the seat of the arbitration, is it?
Yes, Mr. Arbitrator.
Right. You did make reference to NCA against Chubb, though. Didn't the majority agree that an express choice of law for the main governing the main contract should be the law of the arbitration agreement as well? As an
Yes.
employee?
Yes, certainly, Mr. Arbitrator. However, I would like to point out that the reasoning of the NCA and Chubb decision is relevant in our case. However, it is efficiently not applicable in our particular case because the circumstances of our case are very different. So in our particular case, the seat of the arbitration was determined under clause 13(2). That implies that the claimant either agreed that they must rely either, and according to paragraph 10, it can be implied that the claimant either clearly wanted to rely on the seat of arbitration or wanted a separate law governing the arbitration agreement. And on several instances, they made it very clear to the respondent. This shows the implied intention of the claimant. Hence, this differs from the claim of NCA versus Chubb, where in that particular reasoning, the reasoning was very different, because in that the party was the second party could not move into the court for the injunction at all. However, in our particular case, there is no rebuttable presumption. Hence, the reasoning can be reasoning can be applicable in the case and not prima facie the obiter dictum. If you are satisfied with that intention.
One more follow-up question from that. Again, it's because you brought up NCA against Chubb in your submission, so I wonder why does the validation principle espoused in NCA against Chubb at all help your client's case here?
Okay, Mr. Arbitrator. So I think the reasoning stated down in NCA and Chubb is very important to remember. Now, in this particular matter, in NCA versus Chubb, it was stated that the real and the most closest connection must be applied. And I have substantially made it clear to the arbitral tribunal how our client, how the seat of LRAD has the real and the most closest connection to, in case the implied choice is not the seat of arbitration. And the validation principle is purposive, and it finds some application in our case. If you are satisfied with this answer.
Not really, but I think let's move on to the second point that you're going to make.
Okay, thank you, Mr. Arbitrator. Now, moving on to my second submission, members of the tribunal, the pre-arbitration clause does not preclude the jurisdiction of the arbitral tribunal because, firstly, the claimant sufficiently fulfill the conditions of the pre-arbitration clause. And secondly, in any event, the pre-arbitration clause is not a necessary precondition to arbitration. Now, on my first point, members of the tribunal, the purpose of including a multi-tier dispute resolution clause is to allow the parties to resolve their dispute in a less time-consuming manner. The pre-arbitration clauses should be interpreted in the context of the behavior of the parties and the circumstances surrounding the dispute, and should not be blindly enforced if these clauses may cause undue delay in the resolution of the dispute. In the present case, the respondent completely denied any liability for malfunctioning of the photovoltaic panels, while the local default council threatened to institute legal proceedings against the claimant if they did not reimburse the $1 billion loan guarantee within the subsequent 3 months. With the time being of the utmost essence in the resolution of this dispute, and despite this lack of cooperation shown by the respondent, the claimant initiated the discussion with the respondent regarding the dispute on 10th March 2021 in furtherance of the pre-arbitration clause contained in contained in the agreement, which is also mentioned under Article 13.2 of the Ultra Solar Project Agreement, given in paragraph 9 of the Moot problem. However, the parties could not reach a consensus on the problem throughout the discussion and failed to reach a clear resolution of the dispute, which is mentioned in paragraph 19 of the Moot problem. Since the discussion with the respondent was reaching no clear conclusion, and given that the claimant required the dispute process to move forward in a timely manner, the claimant filed a request for arbitration with the Asian International Arbitration Center. Hence, the claimant sufficiently fulfilled the conditions of the pre-arbitration clause. Moving on, members of the tribunal, I submit that in any event, the pre-arbitration clause is not a necessary precondition to arbitration. Now, most national courts and tribunals have been reluctant to hold pre-arbitration to be a mandatory precondition to arbitration, given that they are inherently voluntary processes. Now, under the law of ELIRAD, pre-arbitration clauses are not mandatory in nature, given under paragraph 24 and 29 of the Moot problem. Given that the law applicable to the arbitration agreement in the present case is the law of ELIRAD, as we have sufficiently proved to you, it follows that the pre-arbitration clause will not preclude the jurisdiction of the arbitral tribunal in resolving the dispute between the parties. Even if the contrary is true, even then the tribunal's jurisdiction is not barred, because firstly, the claimant has satisfied the best effort obligations, and secondly, the pre-arbitration negotiation is not a mandatory requirement. At most, the matter of the pre-arbitration clause would form a contractual obligation, the status of which could be determined by the tribunal during the course of arbitration proceedings. Hence, the pre-arbitration clause is not a mandatory requirement, as the parties should not be made to engage in futile negotiations that lead to undue delay in the dispute resolution procedure. Hence, I finally submit that this tribunal has the jurisdiction to resolve the dispute between the parties, and the law that governs the arbitration agreement is the law of ELIRAD law, and that the law of the substantive contract will not govern the arbitration agreement due to separability doctrine. Finally, the pre-arbitration clause does not form an impediment to the arbitral proceeding, since the claimant sufficiently fulfilled the pre-arbitration clause requirement, but also because such a clause is not a necessary precondition to the arbitral proceeding. With this, we'd like to rest our case. Now, my co-counsel will address the substantive issues. Thank you, members of the tribunal.
Hold on, counsel. I have some questions for you. You mentioned that there was an urgency, and that was why you could not fulfill the 30 days requirement, but you did instead use your best efforts in the negotiation. That was your submission, right?
Yes, Mr. Arbitrator.
So I may have misunderstood something. Could you enlighten me as to what this urgency was?
Okay, Mr. Arbitrator. So firstly, the claimant expressed the concern that the 30-day period was too long. And the urgency in this particular case was the reimbursement of the $1 billion within 3 months, which was supposed to be made to the Dhafar local council by the claimant. Hence, we can sufficiently prove to you that time was of an essence, and the negotiation spanned over the period of 10 days deemed to be futile. Hence, time was of an essence, and due to the same, we have moved to this tribunal. If you are satisfied with the answer.
Have you received the outstanding payment?
Mr. Arbitrator, that wasn't initiated to us.
You've not.
In the Moot problem.
So I'm afraid I don't see what the urgency is here for you to commence proceedings when payment was supposed to have already been made quite a long time, even before this arbitration had commenced proper. I would have thought that if there was some level of urgency, you'd seek some form of an interim remedy, either with the tribunal through an emergency arbitrator or some interim measure, or through one of the courts or of the relevant forums here, I don't see that the claimant has done that. So I fail to see where the urgency is. Am I missing something?
Okay. Mr. Arbitrator, I completely understand your concern, but the urgency in our particular case is that the Dafar Local Council threatened to initiate legal proceedings against our client due to the malfunctioning of the solar panels, which was the onus of the respondent to provide us with good panels, which they did not, and we shall deal with them in the substantive clause. And due to the malfunctioning of the panels, now our client is in a position answerable to the Dafar Local Council. So the immediate threat of these legal proceedings and also the burden of reimbursing the $1 billion loan guarantee puts our client in a very unfavorable position. Hence, it can also be implied that time was of an importance since we have only 3 months in our hands.
Now, number one, it goes back to the same question again. Even if there was a threat by counsel to compete against you, I've not seen any immediate measures that were actually taken to remedy the situation by your client. I've not seen any applications for interim remedies anywhere in the facts, unless I'm missing something. And I think that really impacts the credibility of your urgency argument here. And second of all, you mentioned that you can imply that time is of the essence here. But again, I believe your learned friends had argued that there is an entire agreement clause here. So if time is not stated to be of the essence in this contract, then why should we be implying one? So I suppose it's a two-part question.
Okay, Mr. Arbitrator, I understand your question. Now, firstly, the claimant fulfilled all, as I have mentioned before, the claimant fulfilled all the conditions to the pre-arbitration clause by constantly sending emails to the respondent as given under paragraph 16 and further on. This shows that the claimant did duly fill all its obligations. Secondly, as I've proved to you, the urgency was that the Dafar Local Council was threatening to initiate legal proceedings, and the return of money for the pre-arbitration negotiation was not leading anywhere because the respondent was clearly not coming in a consensus with the claimant. They were just putting away their liability. Hence, we have approached this tribunal in the instances. Now, the purpose of the negotiation is to resolve dispute in a timely manner. That is the whole point of coming to the arbitration in the first place. Therefore, the clause impliedly includes the aspect of time being an essence. And if you are satisfied, moreover, we contend that the pre-arbitration proceedings, they were not very clearly drafted by the claimant, by the respondent themselves. Hence, we say that since the pre-arbitration clause is also very loosely worded by the respondent, it is not favorable in our case, and we have brought the claim in this particular tribunal.
Thank you. I think you've far exceeded your time, so I think I'll stop here unless my fellow co-arbitrators have questions for you.
Sorry, I am wary of the time, but I think there is one point I would like to make or to ask. If I read the Moot problem correctly, there is a distinction between Bauer's model law, which makes pre-arbitration clauses a mandatory requirement, and ELIRAD model law, which does not. But I read that as going to the inclusion, whether it is necessary to include a clause. But once the clause is in the contract, does it not need to be complied with, regardless of whether it was necessary to have the clause in the first place? I would be grateful for counsel's views on that.
Thank you, Mr. Arbitrator, for your question. Now, I completely understand your concern. However, we have contended that the doctrine of separability is applicable in our case. Hence, the precondition of necessarily complying with the pre-arbitration clause is not a mandatory requirement in our particular case. We're contending that ELIRAD law, which is the seat of arbitration, governs this particular clause, and ELIRAD law has no precondition of having a pre-arbitration clause. Hence, what we're contending that it is not mandatory, even if not LERAD law, the pre-arbitration, the non-compliance with the pre-arbitration should be taken up as a contractual obligation and not to be considered as a jurisdictional issue.
Just to follow up, so it's not necessary, it's not obligatory upon parties to include this clause, but if parties have voluntarily entered into this contract and freely chosen to have this 30-day requirement, as a matter of contract law, at least, should they not be held to that bargain?
Okay, Mr. Arbitrator. So coming on to the intention of the parties as given under paragraph 10, the claimant clearly raised the concern of reducing the time period of this 30-day period, to which the respondent also agreed. So which shows that there was a certain amount of flexibility that the parties wanted while coming to the 30-day period. However, due to the circumstances, the claimant could not, the final contract could not be drafted. Hence, we're saying that keeping in mind the intention of the parties is the key. It is not mandatory to comply to this contractual obligations per se.
Thank you, Counsel.
Okay.
Thank you, members of the tribunal.
I think before we proceed, we are quite conscious that both counsel have overrun time. I'm conscious that it's probably the arbitrator's fault because we asked you many questions. Bailey, could you please advise on how much time is remaining for each counsel?
For your information, Mr. and Madam Arbitrator, we have 14 minutes and 23 seconds left for the counsel for respondent side, and we have 14 minutes left for claimant.
Right.
Including the rebuttal and rebuttal time. Yeah.
Thank you. So counsel for respondent and counsel for claimants, would you like to advise the tribunal as to how you organize your timing allocation?
Certainly, Mr. Arbitrator, can we get a minute to reconsider the timing with the colleagues?
If it's all right with my fellow arbitrators, yes, you can go ahead.
Mr. Arbitrator, if you may allow, we would like to reduce the rebuttal time from 3 minutes to 2 minutes.
All right. So that will leave you with, I think, 13 minutes for second counsel, yes?
Yes, I believe.
All right.
Or if you may grant a permission of 5 minutes, because under the rules it was stated that a 5-minute extension can be granted.
Yeah, upon request, of course, which I did not receive earlier. So that will be on second counsel, I think.
Thank you so much.
Mr. Arbitrator, we would also like to request a 5-minute extension if possible. And if
yeah, the second counsel can request that and we'll consider it in turn. All right, if that settles the reorganization of the timing, I think counsel for claimant, you can proceed when you are ready.
Greetings, honorable members of the Arbitral Tribunal. As previously introduced by my co-counsel, Ms. Shukla, I am Abhishekta Sengupta, and I shall be representing the claimant on the merits of the case. If I may kindly draw the tribunal's attention to paragraph 12 of the case record, it is seen that the respondent informed my client that it would be unable to supply the agreed upon amount of photovoltaic panels under the contract, and instead orally suggested to my client that it should receive supply of the remaining 5,000 panels from the respondent's second branch in Viagri, Subsequently, the delivery of the 10,000 panels was made by the respondent on the 1st of September, which was 10 days later than the contractually stipulated date of 22nd of August. Within these facts, we seek to put forward two major submissions, the first being that the oral variation made to receive 5,000 panels from the respondent's second branch in Vaigiri is invalid, and the second being that the respondent was in breach of its obligation to make the delivery of 10,000 panels on the 1st of September, which was later than the agreed date. Proceeding to our first submission, I will be seeking to delve into the same in a threefold interrelated manner. The first with respect to the existence of an NOM or a no oral modification clause. The second in regards of for preclusion from asserting said cause. And the third with regards to the principle of good faith and uniformity in application governing the CISG. First and foremost, Article 29, Clause 2 of the CISG states that a contract in writing containing any provision requiring modifications by agreement to be in writing may not be modified in any other form. Furthermore, the CISG Advisory Council has included electronic communications in real time within the ambit of oral. If I may draw the tribunal's attention to paragraph 11 of the case record. As per Article 1 of the Ultra Solar Project Agreement, it is stipulated that all variations to this contract must be agreed, set out in writing, and signed on behalf of both parties before taking effect. Hence, by necessitating all variations to be in writing, this amounts to a no oral modification or an NOM clause. Furthermore, as previously stated, the respondent in a video call session suggested to my client that supply of the remaining panels be taken from the respondent's Vaigiri branch. However, this modification was not written out or signed on behalf of the parties. Furthermore, a video call session is an electronic communication in real time, and thus the variation made therein amounts to an oral variation, which does not constitute a valid modification due to the existence of the aforementioned NOM clause. Proceeding to the second limb of my contention, pursuant to Article 29, Clause 2 of the CISG, a party may be precluded from asserting a provision requiring modification to a contract to be in writing by their conduct to the extent that the other party has relied on the same. It is humbly submitted before the tribunal that my client is not precluded from asserting the NOM clause, as firstly, there was no conduct of my client leading to such a preclusion. While Article 29 does not specify the form of conduct which may lead to such preclusion, Article 8 of the CISG enumerates certain rules for the interpretation of parties' conduct. Specifically, Article 8, Clause 2 lays down the reasonableness standard, which is the understanding that a reasonable person of the same kind as the other party would have had in the same circumstances. Furthermore, in the cases of Chateau des Champs Wine versus Sabate Incorporated of the US Court of Appeals, as well as Soleil versus Hershey Canada, the intention to be bound by an offer of modification has been held to be required to be tested objectively under Article 8, Clause 2, and not with regards to interpreting conduct as acceptance of such offers to modify. This means that mere performance of a contract is insufficient and a clear assent to an offer of modification is required. On the day prior to the oral modification in question, my client expressed certain reluctance regarding the reduction in supply. Hence, the respondent suggested that the remaining panels be sourced from the Vaigiri branch. However, at the time, the respondent assured my client that these panels would possess the same quality and features as the panels from the first or original branch. Taking this into consideration, a reasonable supplier such as the respondent should not have interpreted my client's oral agreement to the modification as such conduct to rely on, given that my client was unaware of the inferior quality of panels from the second branch. Furthermore, as per the Secretariat commentary on draft CISG, an oral modification is effective only insofar as the parties are in agreement to the terms and the terms of the original contract are reinstated on either party's denial of the validity of the oral modification. In an email on the 15th of February 2021, my client denied the oral variation's validity given the existence of the aforementioned NOM clause. This would result in the terms of the original contract being reinstated. Proceeding to my third branch of contention, as per Article 7, Clause 1 of the CISG, regard must be paid to the need to promote uniformity in application and observance of good faith in the interpretation of the convention or the CISG. Permitting the oral variation to be valid despite the existence of an NOM clause would hinder the uniform application of the law governing the contract. Furthermore, should this be taken as precedent and should other NOM clauses be allowed to be overridden in such a manner, parties would be compelled to contemplate all possible methods of modification, potentially increasing contracting costs, as well as subjecting parties to predatory oral modification practices, which cannot be sustained under the good faith mandate of Article 7, Clause 1. Therefore, in order to summarize this submission, there was an NOM clause existing in Article 1 of the Ultra Solar Project Agreement, which my client is not precluded from asserting, given that no conduct of my client led to such a preclusion, and my client denied the validity of the oral variation. Furthermore, constituting the oral variation as valid would be opposed to the mandate of Article 7, Clause 1. I would now seek to proceed to our second submission, which, as aforementioned, is with regards to the respondent's breach of obligation due to the delayed delivery of the panels. I will be seeking to delve into this in a twofold interrelated manner, the first with respect to fundamental breach, and the second with respect to the conditions under Article 79. First and foremost, as per Article 25 of the CISG, breach is fundamental if it results in such detriment to the other party as substantially to deprive him of what he is entitled to expect under the contract. The exception to this is when a reasonable person of the same kind as the other party in the same circumstances could not have foreseen such a result. It is humbly submitted that the delayed delivery did constitute a fundamental breach of the agreement, as it substantially deprived my client of its contractual expectations under the agreement. This is because, firstly, timely delivery was a contractual obligation. According to Article 33, Clause A of the CISG, if a date is fixed by a contract, the seller must deliver the goods on that date. However, as aforementioned, the respondent delivered the goods or the panels on the 1st of September, 10 days later than the contractually stipulated date of the 22nd of August. This is a clear violation of Article 33 of the CISG. Furthermore, breach may be fundamental under Article 25 in cases where the time of performance has been deemed to be essential under the contract. If I may invite the tribunal to refer to paragraph 6 of the Moot proposition, we see that my client stated and informed the respondent of the delivery date, as well as the importance of the same, given that a delayed delivery would impair my client's performance of its contract with the default local council. Furthermore, the nature of goods are essential in gauging whether a non-delivery amounts to a fundamental breach. As the Ultra Solar project could not begin its operation without the delivery and installation of the panels, the panels are deemed to be an essential commodity under the contract, and hence a delayed delivery of the same would lead to a fundamental breach of the contract. Proceeding to the question of foreseeability, the knowledge of the other party must be taken into consideration to ensure the significance of the obligation breached. As aforementioned, the respondent did possess the knowledge by means of my client of the date of delivery, as well as the importance of the same, and the respondent was also informed and intimated of the possible detrimental result of late delivery, which would impair my client's performance of his contract with the default local council. Hence, the result of the delayed delivery was foreseeable. Proceeding to the second limb of my contention with respect to Article 79, Article 79 deals with the effects of impossibility to perform an obligation under a contract and to what extent the non-performing party may be exempted. It is humbly submitted that the respondent is not exempt of its liability under Article 79, as the conditions under Article 79 remain unfulfilled. This is because, firstly, the disruption should have been reasonably foreseeable by the respondent. For exemption of liability under the CISG, the impediment causing the exemption must be unforeseeable at the time of conclusion of the contract. If the same is foreseeable, the party is assumed to have taken the risk or assumed the risk at the time of formation of the contract. Furthermore, as per the Secretariat commentary, all impediments are considered foreseeable to a certain extent, even rare occurrences such as governmental embargoes or the closing of international waterways, as all sellers are expected to take into consideration business risks inherent to their industry. While the delivery of panels was required to be done over international borders, this possessed an inherent risk which any reasonable supplier, such as the respondent, should have taken into consideration, as supply chain disruptions in any business are a foreseeable risk. Furthermore, given that the respondent was the sole supplier of the specific design of photovoltaic panels, a contingency plan must have been put into place from VOWs for the respondent. While the default local council specified the design as they required the newest technology in manufacturing a solar panel, the design remained specified. However, the location of sourcing remained unspecified. According to Article 79, a breaching party is only excused if, despite taking all reasonable measures, the impediment is failed to be overcome. As there was no compulsion to source the photovoltaic panels from VOWs, and no measure was taken to source the panels from any other region, all reasonable measures cannot be said to have been taken. Mr. Arbitrator, seeing as I am nearly out of time, would the tribunal look favorably upon granting me an extension of 5 minutes?
Yes, you can have 5 additional minutes.
Thank you, Mr. Arbitrator. I will simply be concluding and summarizing this submission. We see that there was a fundamental breach, as there was a substantial deprivation of my client's expectations under the contract, and furthermore, the result of the delayed delivery was foreseeable. Additionally, the conditions under Article 79 remain unfulfilled by the respondent, as the disruption was reasonably foreseeable and the delivery was possible despite it. Thank you for your time, Mr. Arbitrator, and the members of the tribunal.
Are there any questions from my co-arbitrators?
Yes, I have one question for counsel. Your co-counsel is arguing for a more expensive interpretation of the arbitration agreement. And likewise, counsel, in your current submissions, you have talked about the relevance of the surrounding circumstances in terms of fundamental breach and so on. Whereas in another submission, you insist very strictly on the no oral modification clause. So do you see any tension between, in one part, insisting strictly on terms of the contract, and in another area, taking a more expensive interpretation?
Indeed, Mr. Arbitrator, we believe that while no oral modifications are not permitted, even in the case of extenuating circumstances, or oral modifications remain precluded given the existence of a no oral modification clause. Hence, an extensive interpretation is not applied even in the case of these circumstances, given that, as I have already substantiated, they were reasonably foreseeable by the respondent, and a contingency plan should have been put into place due to the same.
Just to follow up, in the same way, there is, would the entire, if you were to insist strictly on the no oral modification clause, would the entire agreement clause not also apply, say, in respect of circumstances surrounding the alleged fundamental breach, or in terms of being able to look into the drafting history or negotiation history of the arbitration clause? How does counsel reconcile that?
Mr. Arbitrator, it has been held very recently in the UK Supreme Court case of MWB versus Rock Advertising, that the scope of the preclusion from asserting an NOM clause must not give up on the certainty or destroy the certainty that was assured by the no oral modification clause. Hence, we believe that in spite of all the extenuating circumstances and despite the drafting history, the NOM clause is something we contend to be completely relied on. As while oral modifications may be gone into, they are not considered valid given the existence of the said NOM clause.
All right. Thank you, Counsel. I have a second question on another point, but maybe I will give the floor first to my co-arbitrators if they have any questions.
No, go ahead, Waifeng.
Okay. Counsel, you talked about, you submitted on how the claimant denied the effectiveness of the new term on 15th of February 2021. And therefore, because of this denial, the original terms of the contract are reinstated. Now, what does counsel say to the fact that that denial came almost 1 year after the video call when parties had the alleged oral negotiation when the political turmoil took place? Does counsel view this period of almost 1 year having passed as any obstacle?
Indeed, Mr. Arbitrator, thank you for your question. While our denial of the validity of the modification came later, we do have a reason for the same. This is because initially the respondent, as aforementioned, assured us of the quality and features of the panels remaining the same as that from the original branch. However, we denied the validity of the oral modification after finding that they were of inferior quality. This could only be found at a much later date. If you may kindly refer to paragraph 15 of the case record, it is seen that on the 1st of February, which is 6 months after the beginning of the operation of the ultra-solar project agreement, it was found that the electricity generated was only 40% of the total. While it was assured by the respondent in their certificate that the drop of efficiency, even in temperatures greater than 40 degrees Celsius, which we saw due to the El Nino season, the drop of efficiency would simply be of 5%. Therefore, it is a clear indication, and it may be clearly concluded, that the panels were of an inferior quality. Upon finding out about the same, we were able to raise an objection to the validity of the oral modification.
All right, thank you, Counsel.
Thank you, Mr. Arbitrator.
Just have one short question. I will grant an extension for you just to answer this question. Now, I'm quite conscious based on the facts here. It appears quite clear to me that the respondent delivered and installed the 10,000 photovoltaic panels at the agreed date after the video call session. My understanding based on the facts is that there was this agreement that came about through that video call. Now, I understand your submission that you are asserting that there should be no oral modification of the contract as a result of the terms of the contract itself. But wouldn't it then, in such a case, be that your client is actually abusing or the reliance that was put upon by the respondent on the so-called agreement that was reached in the video call?
Mr. Arbitrator, again, thank you for your question. While an agreement was made on the video call, this was, as aforementioned, simply oral. Again, as mentioned by me in my answer to Mr. Arbitrator's question, we see that this was only upon the assurance of the quality of the panels. Hence, we as well, as you have stated that the respondent may have been relying upon this oral agreement, we too were reliant upon this assurance of quality.
I think a question of quality of goods supplied and a question of whether a contract was properly amended, aren't those two different questions altogether?
Mr. Arbitrator, while it is contended that the quality of panels, given that the panels are an essential commodity under the agreement, the quality of the panels are a question which are extremely relevant to every question governing the agreement, even if it is with respect to the delivery.
It is a bit abusive, isn't it, on the part of your client if you were to be able to assert that no agreement would have been reached if ultimately the goods supplied are not in accordance to our requirements. But if it is in accordance with our requirements, we will agree that an agreement had arisen. That is basically the argument that you seem to be making, which is, I think, quite abusive, isn't it?
Mr. Arbitrator, we do not believe it to be abusive. It was not contended that should they have been of an appropriate quality, we may have accepted the validity of the modification, as there is nothing that stated in the case record which indicates the same. However, we have seen numerous cases, as I have stated and substantiated, that the extent of the no oral modification clause is overarching. Therefore, that would stand given all circumstances. As this case specifically pertains to the quality, we deem it fit to use this question to support our argument.
The NOM clause is overarching, yes, but does Article 29 provide for any exceptions to that?
It does provide for an exception, Mr. Arbitrator, with respect to other parties relying on the conduct of the party. However, as it has already been substantiated, there was no conduct of my client which led to such a preclusion from asserting the NOM clause.
All right, thank you.
Thank you, Mr. Arbitrator.
Sorry, I just have a quick question. Following from my learned arbitrator's question, just a very short question. Would you agree that your client did, by virtue of the phone call, agree to that modification orally?
While there was an oral agreement, we agreed that there was an oral agreement, Madam Arbitrator.
Okay, so taking that there was an oral agreement, which you have consented to, and it's not in dispute, would you also agree that by way of your conduct, you did deliver?
Madam
batch,
Arbitrator,
correct? You did.
Madam, apologies, Madam Arbitrator, could you kindly reiterate what we agreed to?
You did, by way of your conduct, after consenting to it, did deliver. Correct? There was a performance of the contract.
The delivery was on the part of the respondent. The performance of the contract from our end, the performance
there was performance of the contract, correct?
There was a performance of a contract, Madam Arbitrator. However, as aforementioned, a performance is not sufficient and a clear assent to the offer of modification is required.
Was there any objections on that by your client?
By my client was an objection on the scope of the oral modification in an email on the 15th of February.
Right. And by virtue of that, what would you say, what smacks on the conduct of your client by now stating that you're relying on the NOM, whilst on the other hand, at that material time, your conduct states otherwise?
Madam Arbitrator, we believe that our conduct at the time of agreement, again, was dependent on the quality of the panels. Given the inferior quality...
You do agree that there has not been any express on that matter. There's no express intention or there's no express conduct by your client that it was dependent on the quality, correct?
While there has not been an express intention, it is as we were reliant on the assurance of the respondent and did not believe that the question of quality would even arise.
Right, okay.
Thank you, Madam Arbitrator.
Thank you.
Thank you, everyone. Can we now hear from counsel for the respondent?
Firstly, please let me know whether I'm clearly audible and visible.
Yes.
All right. Greetings, honorable members of the tribunal. My name is Anisha Sharma, and on behalf of our client, Zoka Green Energy Limited, I shall be addressing the substantive issue of the dispute over the course of next 13 minutes. Members of the tribunal, our client enter into a contract with the claimant to supply 10,000 photovoltaic panels. It pulled out all stops to ensure that it fulfilled the contract in time. It fulfilled the contract to the maximum extent possible, despite there being various unforeseen and impeding circumstances. In the light of the same, I shall be addressing two key issues. Number one, the oral variation made to receive another 5,000 photovoltaic panels from the respondent's second branch in Viagri is valid. And second, the respondent is not in breach of its obligation to deliver 10,000 photovoltaic panels on the date later than the agreed date. Proceeding with the issue relating oral modification, our submission is twofold. Number one, the claimant and the respondent agreed to modify the sales contract pursuant to Article 29 of CISG. And second, oral modification of the contract was a reasonable conduct on the part of both the parties. Proceeding with the first part of our submission, I seek to establish that a contract can be orally modified according to Article 29 of CISG, where a contract may be modified or terminated by mere agreement of the parties as per Article 29(1) of CISG, and the agreement was validly modified in accordance with Article 29(2) of CISG. A contract may be modified by mere agreement of the parties. This can be proved in a variety of ways, including their actions. Both claimant and respondent had agreed to the new contractual terms over a video call, which indicates that they had mutually entered into an agreement for the oral modification of the contract, making it enforceable under Article 29(1) of CISG. As my learned counsel for claimant has indicated that under Article 29, a written contract which had a provision of no oral modification cannot be modified otherwise as per 29(2) of CISG. However, it is our submission that the application of NOM clause may be avoided under Article 29(2) of CISG when one party justifiably relies on the other party's conduct that gave rise to and conveyed the modification to the contract. And in the present case, the claimant relied on the respondent's conduct. However, there is a content by my learned counsel for the claimant that there is no conduct. However, I would like to show that there was a conduct from the following instances from the agreed facts. First, that the claimant had granted its consent to modification without considering the NOM clause mentioned in Article 1 of USPA, which constitute a sufficient conduct on the part of the claimant. According to a writing by Professor Perils Viscalis, a proposal for or consent to a modification made without adhering to the requirements agreed in the original agreement can be considered a sufficient reliance-inducing conduct. Therefore, this conduct of claimant validates the reliance. However, when the respondent was in process of manufacturing another 5,000 photovoltaic panels, the claimant did not pose any objection to the oral modification over the course of time. This confirms that the claimant relies on the respondent's conduct. And the third, that the reliance can be shown on the part of the claimant by it accepting the delivery of those panels for the second branch of the respondent. Therefore, the oral modification is valid under Article 29(2) of CISG. If this satisfies the members of the tribunal, may I proceed towards the second part of my submission? For the second part of the submission, I would like to establish that the oral modification was a reasonable conduct on the part of both the parties pursuant to Article 8(2) of CISG, which states that statements made by a party are to be interpreted according to the understanding that a reasonable person of the same kind in the same circumstances has taken. In this process, due consideration is given to all the relevant circumstances of a case, as well as to the subsequent conduct of the parties as per Article 8(3) of CISG. In the present case, the claimant reasonably interpreted the respondent's suggestion of delivering another 5,000 photovoltaic panels from the second branch in the wagon and agreed with the new contractual terms and agreed not to sign the agreement because of the prevailing obstacles to do so. Thus, the claimant, being a reasonable person, has given due consideration to the unforeseen and impeding circumstances. However, it's the content of my learned counsel for claimant that the reasonable reliance of the claimant was on the quality. However, I would like to point out that there was a condition in the agreement that there need to be regular inspection by the claimant. However, there is no evidence in the agreed facts that the regular inspection was conducted by the claimant. Now, moving forward, I would like to conclude this issue by saying that the tribunal should give effect to the oral variation made to the contract. The claimant and the respondent has modified the contract as per the Article 29 of CISG, and the oral modification was reasonable conduct on the part of both the parties. Therefore, the oral modification to the contract is valid. If this satisfies the members of the tribunal, may I proceed towards the issue of late delivery? Proceeding with this,
just on the point of inspections, am I understanding right, if I look at paragraph 13 of the clarifications on the moot problem, is it not a fact in this case that inspection was regularly done in the first 2 months?
Mr. Arbitrator, according to the inspection, the inspection is to be done every week regularly. And if there was any, if there was any non-conforming from our part, then there could be a conducive evidence they could have found during the first few months after the delivery. However, after the 5 months of delivery and after the functioning of them, when they conducted a maintenance, then they sensed some non-conformity on the part of the panels. However, it is our contention, if there were regular inspection that is to be done every week, then it could have been, they could have known about the non-conformity at the very beginning. And from this, we could infer that there was no regular inspection on the part of the claimant.
Counsel, just to explain a bit more, where is, I'm grateful counsel to point to where in the case record it says that the claimant did not carry out weekly inspections as stipulated.
Mr. Arbitrator, there is no conclusive evidence given in the agreed facts, but however, in drawing the inference from the subsequent actions and the previous action, we could conclude that there was lack of a regular inspection on the part of the claimant.
I'm just struggling to understand how that conclusion is reached. If I understand your steps of your reasoning, Council, you're saying that because no issues were found, therefore this shows that no inspections took place. Because had inspections taken place, they would have found issues. Is this not sort of reversing the reasoning, which just if you could explain this more.
Mr. Arbitrator, my contention is that as they found the issue after 5 months when they conducted the maintenance, and the regular inspection are to be conducted every week. If they in the report, if I may refer to the paragraph 15 of the agreed facts, it's mentioning that it is non-functioning. It generated only, if I may reiterate from the paragraph 15 line, second line, that it was reported that the electricity generated was only 40% of the total 350 megawatt in the first 3 months of its operation. If there were regular inspection that is to be conducted every week, and then they could have sensed the issue in the first 3 weeks that was reported during the maintenance. Therefore, it could be inferred that there was no regular inspection conducted by the claimant.
Sorry, Council, just this is my last question on this point. Does Council have sites of the clarifications on the moot problem?
Yes, Mr. Arbitrator.
And if I could take Council to paragraph 13.
If I may draw the attention of the members of the council to clarification number 16. Which states that the claimant is responsible for both regular inspection and maintenance, and the term inspection refers to the regular inspection which must be done every week as stipulated in this certificate.
Okay, so, and if we go back to paragraph 13, it says that inspection was regularly done in the first 2 months after our solar project began operation. So I accept that there is the facts are not clear on whether in the 3rd month they continue to do these inspections, and so I leave that aside. But the problem, as I understand it, is that in the first 3 months of operation, there was only 40%. Unless that gap of 60% is entirely attributable to the 3rd month only and not to the first 2 months, is it not relevant that, as in paragraph 13 of the clarifications, that the claimant has in fact done these weekly inspections, at least for the first 2 months?
Before answering your question, Mr. Arbitrator, as I'm running out of time, may I ask for extension of 5 minutes?
Mr. Presiding Arbitrator, would that be okay?
Yep.
Mr. Arbitrator, so assuming the fact that they have conducted the inspection for first 2 months, however, as it was written in the original contract, that it is to be conducted every week. If they haven't conducted the inspection in the 3rd week, then they are not conforming to the obligations of conducting inspection every week in the 3rd month. So therefore, here also they are lacking with their obligation to conduct the regular inspection every week.
All right. Thank you, Councillor.
Much obliged, Mr. Arbitrator. Proceeding with the the second issue of late delivery. If I may proceed, that I will proceed with our submission where I seek to establish that the respondent did not breach the contract, taking Article 79 of CISG as the main basis. The respondent gets the exemption under Article 79 of CISG, which establishes that if the respondent's failure was due to an unforeseeable and unavoidable impediment beyond its control. Second, the respondent could not reasonably expected to have taken the impediment into account at the time of the conclusion of the contract. And third, the impediment was the cause for the respondent's failure. As my learned counsel for the claimant has pointed out, that the result was foreseeable. However, at this point of time, I would like to draw the attention of the arbitrator to the clarification number 17 and the last line of clarification number 17, which states that it wasn't foreseeable by the respondent, the impediment. However, with this, I draw the inference that as the impediment was unforeseeable by the respondent and it was beyond the control, as there was a sudden change of the government that couldn't be enforced by any of the parties. Therefore, it was beyond the control and unforeseeable. Considering that the respondent could not reasonably expected to have taken impediment into account at the time of the conclusion of the contract, as the contract was finalized in the month of February, and there was a sudden impediment that happened in the mid-March. So it's a general assumption on the part of the parties that they couldn't have expected that the impediment could have taken place in future. And impediment was the cause for the respondent's failure, as there was the impediment here is the closing of the international borders, and they couldn't deliver the goods because of the closing of the international borders. However, with this, I would like to conclude my issue that the respondent is not liable for the non-conforming to the late delivery, as there was an impediment that was beyond the respondent's control, and the impediment was unforeseeable and unavoidable in any circumstance by the respondent at the time of concluding the contract. The impediment was the cause for the failure to deliver on time, and the date of performance of the date falls under the impediment period. Therefore, I conclude my submission on the merits of the dispute with this. Thank you, members of the tribunal, for your time.
Unless there are any questions by my co-arbitrators, we can move to rebuttals.
None from me.
I'm conscious. Thank you, everyone. I'm conscious of the time, so can you keep your rebuttals only to 2 minutes, please?
Should I begin with the rebuttals, Mr. Arbitrator?
Yes, please.
Thank you. My rebuttals for the procedural speaker of the claimant are that, first of all, as rightly pointed out by Mr. Arbitrator, while the claimant procedure speaker is arguing that the entire agreement clause does not apply, the claimant speaker for the merits is arguing that the entire agreement clause should be applicable. This sounds in contradiction. The two arguments that they're making are contradictory to each other. Second of all, I would also like to point out that the pre-arbitration clause mentioned in the agreement had a shall, that it was shall. And it has been established by Gary Vaughan, which is a recognized commentary, that when words like shall are used in pre-arbitration clauses, they are required to be mandatorily followed. I would also like to point out that the rationale given by the claimant procedural speaker for ICAMC case, as even rightly pointed out by Mr. Arbitrator, was wrongly quoted and would not be in favor of the claimant. I would also like to point out that they have not responded to the express choice argument made by me in the present matter. And with that, I would like to once again argue that this case, this tribunal should dismiss this case on the basis argued, and as this tribunal lacks a jurisdiction, and this case should be dismissed on the outset. With that, I rest my rebuttals.
So rebuttal.
Yes, members of the tribunal. So I shall be dealing with the procedural rebuttal, while I will be very short with my procedural rebuttal, and then my co-counsel shall rebut the merits-based rebuttal, if that is okay with the tribunal.
Yes, please.
Okay, so thank you, members of the tribunal. So on the first rebuttal raised by the respondent, members of the tribunal, I have one primary point to make through this rebuttal. Even if there exists a presumption in favor of the substantive law to apply to the arbitration agreement as contended by the respondent, this presumption is rebuttable, as was held in the case of Sula America, as well as the recent BNA versus BNB case mentioned by you. Given the material difference in neutrality and the implementation of a pre-arbitration clause in the two laws, it is the LIRAD law that has a more real and close relation as it reflects the intentions of the parties. So with that, we conclude a procedural rebuttal, and now the co-counsel will take on the merit-based rebuttal.
Thank you, members of the tribunal. So in the interest of time, I shall only be dealing with one specific rebuttal. My learned opposing counsel stated that there was no evidence that regular inspection had been done. However, as per clarification 13 to the Moot proposition, as was stated by my opposing counsel herself, it was stated that in the first 2 months, regular inspection was conducted and no issues were found. Therefore, we do not believe that a question on due diligence on our part is applicable. Furthermore, in the second limb and interrelated to the same, it is found in the same clarification that the malfunction was due to the overheating and not due to any other reason such as the lack of inspection. As the overheating, as the malfunction due to overheating can only be attributed to the quality of the panels, this question and this query can only be attributed onto the respondent, and only the respondent can be liable for the same. In the third month, which is the month of November of the beginning of the Ultra-Solar Project Agreement, this is when the El Nino season began. So in the first 2 months, there were no objections, as the objections arose due to the overheating of the panels due to the El Nino season, which began in the third month itself. There rests my rebuttal.
For the third rebuttals, I would like to say, as though there was a regular inspection in the first 2 months, but there is no conclusive evidence about that there were regular inspection in the third month. It was being come to the notice after the 5 months. If there was a regular inspection in the third month, then they could have sensed that there is an issue in the third month itself. So therefore, there was no conclusive, there was no regular inspection. The inference could be drawn that there was no regular inspection in the third month. So therefore, there is a non-compliance of the obligation by the claimant as per the original contract. Thank you.
Thank you, everyone. I think that concludes the proceedings, and I declare the hearing closed. Bailiff, what is the next order of proceedings?
Teams and arbitrators, we will now proceed to the feedback session. Or the arbitrators would like to have a deliberation session before we give the feedback to the councils.
Yes, please.
All right, so we will now proceed to the deliberation session. Therefore, I would like to kindly request all the councils to leave the breakout room and return to the general room. After the deliberation session, we will, our technical team will assign you back to this room. The council.
Sorry, will the technical team be here as well, or do we get moved into a breakout room as well?
Mr. Daniel, would you like to have a private
Yes.
space? All right, sure. May I know how long would the arbitrators would like to take for deliberation session?
Probably 5 to 10, let's say 6 minutes. Yeah.
All right, sure. I will be my team will help to assign me to this room at around 11:57 or 58, something like that. If that time the arbitrators are still deliberating, then we will quit and rejoin.
Okay, thank you very much.
All right, sure, no problem. We will now leave the breakout room.